centre's delay in clearing 70 names for judgeship recommended by various High Court has irked the Supreme Court. After the Attorney General sought a week's time to come back with instructions on the pending recommendations, Justice Kaul delivered his first message expressing distress. He said, and I quote, "I thought of saying a lot, but since the attorney is asking for 7 days, I'm holding myself, but I will not be quiet on the next date." Unquote. Now, the two-judge bench of the top court panned the central government, reminding them that 70 recommendations made by the High Court's collegium is pending since November 22nd, including the appointment of the Chief Justice of a sensitive High Court, indirectly referring to Manipur, which has been on the boil since the start of May. The Supreme Court also expressed concerns over the fact that the delay appointments would lead to great candidates losing interest and withdrawing their name, which in turn tarnishes the image of judiciary. Now, my colleague Ila talked to former Law Minister Ashwani Kumar over the row. Kumar says the government should not just play a rubber stamp role in judiciary and that the government is entitled to have their own say in some appointments. That is why there should be a healthy dialogue between the two. Listen in.
Well, the Supreme Court has made an observation that they are disturbed at the delay in the government's acceptance of the recommendation. To be fair to the Supreme Court, in the present system of appointments, where the Supreme Court has the final say in the matter of judicial appointments, the delay on the part of the government disturbs the court. That is why one of the senior-most judges has expressed his dismay yesterday. I do hope that the government will take cognizance of the observations of the court and hasten the process of approval. But having said that, I do not subscribe to the view that the government has to be a rubber stamp of the judiciary in the matter of appointments. The government is entitled to have its own say, its own views in matters of some appointments, and therefore there should be a healthy conversation, a healthy dialogue between two institutions, namely the judiciary and the executive. That is the only way forward. In a constitutional democracy, the powers of appointment, even of the judges, cannot be concentrated entirely either in the hands of the executive or the judiciary. But the present system of appointments certainly needs to be tweaked. That there should not be a situation of a rift between the executive and the judiciary, least of all in the matter of judicial appointments. I think both the government and the Supreme Court would be interested and ought to be interested in ensuring that the best people get appointed to the higher judiciary. The rift which one has been seeing for some time now needs to be removed, and there should be a healthy communication at the administrative levels between the head of the judiciary and the government in order to smoothen the creases, if any. Don't think that the government would unnecessarily want to delay the appointments, but if indeed that is the case, it is a matter of concern. I think the real issue is what is the kind of interaction that the executive and the judiciary must have in the matter of judicial appointments. The government of the day obviously cannot be treated as a rubber stamp in the matter of crucial appointments, although the Supreme Court must have its rightful say in the matter, and as of date, as in the case of the present system of appointments, the final say is that of the Supreme Court.